Justices of the Constitutional Court, all counsel are online. I call the matter of Liqhayiya tutor and the state for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you.
May it please the court, I appear together with Mr. Brickhill for the applicant.
Thank you, Mr. Liqhayiya.
Morning, Justices. This is Alicia Roos from the DPP's office, appearing on behalf of the respondent, together with Advocate Janse van Vieren.
Thank you, Ms. Roos. Yes, Mr. Liqhayiya.
Thank you, Justice Madlanga. What I propose doing is to address three distinct topics. The first is whether the conviction, both convictions on the grounds of murder and the conviction for attempted murder were vitiated by material trial irregularities, which undermined the applicant's rights to a fair trial. The second is whether or not the judge, in any event, the judge à court, appreciated the correct test for the defense of putative private defense and consequently correctly applied it. I must confess that in relation to the second topic, there is a substantial overlap with a factual evaluation, which may make the case similar to S versus Basson. But I argue that what my contention is that the complaint is about the correct test for a putative private defense. And I will submit to the court that it is not possible to appreciate that test unless there is an assessment of the facts. The third question is whether, as per the directions of this court, the decision of a judge in imposing a sentence under the provisions of sections 51 and 53 of what is referred to generally as the minimum sentencing provisions, which is the Criminal Law Amendment Act of 1997, exercises a discretion in the conventional common law sense, or in reality a value judgment, which comprises the application of a statute in the context of a given fact, of given facts. We will submit that the proper understanding of the role of a sentencing judge when applying the minimum sentencing provision is that they exercise a value judgment. That is material consequences for the role of this court on appeal, that a court is not constrained in the same manner that it would have been had this been exercise of a discretion. The only feature that an applicant must satisfy the court with is that indeed the judge à court erred. If I could then commence with the first question. We submit that there were two material trial irregularities which vitiated the conviction because they adversely impacted the fair trial rights of the applicant. And because these irregularities relate to the conduct of the judge during the trial, they fall outside the net, the factual net of S versus Basson. The appeal is thus squarely on questions of law rather than a disagreement with a mere factual assessment and findings of the trial court. The first of these two irregularities concerns the question whether or not the applicant understood the case against him. On the central point of his defense, the court will recall that Mr. Engelbrecht, counsel for the applicant, stated at the commencement of the trial that the defense of the applicant would be putative private defense. In order for that defense to fail, the state had to establish that the applicant subjectively intended to act wrongfully. And that is a crucial test, that he subjectively intended to act wrongfully. In other words, he subjectively knew that his conduct was wrongful. Now, in order to overcome this hurdle, the state had to prove that he knew that the two gentlemen who accosted him and chased him were policemen, and despite that knowledge, acted in the manner that he did. Now, on that very central issue, there are two parts of the evidence that are crucial. The first is at page 898 of the record. Now, I know that there have been, I think, 2 different records filed, but on mine, it's page 25 of the typed record and page 98 of the paginated record. So it's typed in the middle as 28, as 25, and then on the right-hand side as 98. That is where the first point is put to the accused by the prosecutor, where it is said to him, because the police officer testified that he screamed in English, "Police, stop, I am going to shoot you." So he is using a language that you do understand. The accused's answer was clear. The police never said that to me. If they had said, I would at least be relieved and feel safe and I would stop. It says here shop, but it's clear that it is intended to say stop. We know here that this testimony was completely corroborated by Mr. Nkuna, who was present at the time. And we know from the police's version that it was only Mr. Makhafela who testified and there was no corroboration of his evidence. The second part on this crucial part of the evidence is at page 107. And this is the most crucial. And it's the middle page 34 and the paginated page 107. And Ms. Ross says, Constable Makhalifa said that the first time he saw you, he followed you on foot and he was wearing his reflector bulletproof vest. The accused then starts answering, as I testified, that the first time we saw this red polo, it was at the T-junction at Riley Street. And the people that I saw, none of them were wearing a bulletproof vest. So for the second time, he makes it clear that his version is that he was not aware that he was being accosted by policemen. But then look at what happens next. The court then interjects, and this is where the trial irregularity comes in. Ms. Rose, is there any sense in confronting the accused with the state's evidence at this point in time? You know what his version is. And Ms. Rose then says, yes, my lord, as long as there is, it's clear that what she then says thereafter is that as long as you don't draw an inference from the fact that the state did not put its case, then I leave it to my lord. Thereafter, the cross-examination is terminated. Now, that intervention by the judge is at a crucial point where the state intends putting its case to the accused, and particularly on the crucial point of whether or not the accused knew, because on the putative private defense, it must be established that he subjectively knew that the 2 gentlemen were not police officers, but that was curtailed as a consequence of the conduct of the trial judge. So we say that it is this intervention that resulted in a trial irregularity that vitiates the conviction, because at this point in time, it was never put squarely to the accused that he subjectively knew that the 2 gentlemen were in fact police officers. So what this meant is that the subjective knowledge that what we've referred to in our heads as assailants were police officers was never truly tested. The reason why this was so was because the judge curtailed the cross-examination, which had the consequences for the fairness of the trial. That is irregularity number 1, which is obviously central and is clear on the facts. It's actually quite glaring on the record. The second irregularity that we referred to is the total failure of cross-examination on an issue which became central in the conviction of the accused. And that was the question whether or not the applicant reported himself to the police. The judge found, in fact, and rejected the version of the applicant that he had reported himself to the police. And in fact, one of the reasons the accused was convicted was that he did not immediately after the incident report himself to the police. We see this at page 170, 172. The judgment itself is at page 161. But we see the conclusion of the judge at page 172 to illustrate the centrality of the finding that the accused did not report to the police. It is at line 20, where the judge says the unreasonable and unexplained conduct of the accused after having been attacked and seriously injured is by attackers by reporting the matter to security guards, friends, and family without success and not calling the police and reporting the matter. His explanation that it did not cross his mind at the time was clearly not true. He obviously had a motive, and that is where the finding against him is made. He obviously had a motive not to report to the police soon after the incident because he knew quite well that he had stabbed policemen. Now, the court will know.
Excuse me, Mr. Liqhayiya, just the
10 minutes,
page number. Sorry, Justice.
Page number is 172, Justice Majid.
Mine is numbered differently. What paragraph are you reading in the judgment?
It's paragraph 20 of it's page 11 of the judgment.
Yes, yes.
Paragraph 20.
Thank you.
Page 11 and 12. Paragraph.
Thank you very much.
Justice Madlanga,
the 10 minutes. The 10 minutes is up. Please continue.
Yes.
Please continue, Mr. Ngai.
Thank you. So it's clear that the judge was materially influenced by his conclusion that the accused did not report the matter to the police. And had the judge been of a different view that he did in fact report, it's clear that that would have influenced the assessment of the evidence. But here is the problem. Given that there was a total failure of cross-examination on this topic, the applicant was entitled to believe that his version, that he reported the matter to the police, would be accepted to be true, and that it would not be used against him in the judgment that was delivered by the judge. The correct legal position on this is set out in SARFU. What are the consequences of a failure to cross-examine? At paragraph 61, SARFU, the recusal SARFU. Now, this is what the court, I think it might have been Charleson CJ, who said the following in paragraph 61. The institution of cross-examination not only constitutes a right, it also imposes certain obligations. As a general rule, it is essential when it is intended to suggest that a witness is not speaking the truth on a particular point, to direct the witness's attention to the fact by questions put in cross-examination, showing that the imputation is intended to be made and to afford the witness an opportunity, while still in the witness box, of giving any explanation open to the witness and of defending his or her character. If a point in dispute is left unchallenged in cross-examination, the party calling the witness is entitled to assume that the unchallenged witness's testimony is accepted as correct. Now, that we say is precisely what should have happened in this case, is that given that the accused was never confronted about whether or not at subsequent, in fact, his version was never contested, that subsequent to the incident, he spoke to his sister, who told him that they would report the matter to the police the following day. And as a matter of fact, he did go to the Sunnyside police station and reported himself. And in fact, that act of reporting himself is perfectly compatible with the version that he gave, that he had no knowledge that the two gentlemen that he had accosted him were in fact policemen. And the significance of this part of this irregularity was that according to Colonel Makhafela, he could not identify the applicant. His version was that he did not know the applicant from a bar of soap, and that the applicant was arrested at Indwe, which was his place of residence, where he stayed, which is the place that the applicant had given to the police. He had told them where he stayed when he reported the incident. So that where we are at this point in time, we have a scenario in which the crucial part of the state's case on intention, in other words, knowledge of the unlawfulness, was never put to him. We have a scenario where a crucial part of the case of the state, which is a failure of the applicant to report himself, was never disputed by the state. In fact, it was substantially accepted because it was never put in dispute in cross-examination as required in some.
Mr. Liqhayiya,
Yes.
let's start with the first one, the first alleged irregularity,
Yes.
where the court interrupted the state when it was busy cross-examining the applicant.
Yes.
What would be the outcome if we were with you insofar as that is concerned? Does that mean that one would have to set aside the conviction, remit the matter for a trial de novo, or what?
Yes. Where there has been a failure of justice in the way that I've tried to illustrate, that would mean that the trial rights under Section 35 of the accused have been violated, which has the effect of vitiating the trial. So you would have to set aside the conviction because this is an unsafe conviction. Whether or not the state wishes to bring the accused back to trial must be its decision. But we would submit with respect that it is not now open to the court in the absence of any request by the state to remit the matter for a fresh trial. It must be up to the state to elect what to do. What we are concerned with here is whether or not there is conduct of the judge Akua that vitiated the trial. And we submit with respect that these two material irregularities have vitiated the trial, resulting in the failure of justice. It is enough for the court to declare that there has been a failure of justice and also to set aside the conviction. This is an unsafe conviction.
Okay. Now, my second point, I know you still have to deal with it, but as you deal with it, that is a test. I'd like us to go to the judgment. I must confess, I have an old record, so I'll give you my page number. It's page 3 of the judgment. That is where the court starts with its evaluation. At line 23 of that judgment at page 3.
Yes,
where the
yes, Justice Mhlantla, I have it.
You found it. The court says it follows that the accused defense firstly amounts to private defense, or more commonly known as self-defense, a defense excluding unlawfulness, where the test, I think it should be, is objective.
Yes.
And secondly, putative self-defense, which relates to the accused state of mind and where the test is objective.
Yes.
The test to be applied in respect of the accused, he generally held it mistakenly believed that he was acting in lawful self-defense, or whether his belief was also held to unreasonable ground. I don't understand what he's saying there. What is the test? Is it objective or supposed to be subjective for a putative self-defense?
It's clearly
if you could deal with that.
Yes. Yes, that is the next part of what I'm going to address. Perhaps I should finalize this topic, the two topics. What we submit there is that these two irregularities are material. These are not marginal mistakes. These are material irregularities. They could have affected the assessment of whether or not the state had proved its case beyond reasonable doubt. And what they ultimately resulted in is an unsafe conviction, which we submit this court with respect should set aside. If I can then come to where Justice Mhlantla is at. The first topic, of course, is to identify what the test is. And Justice Mhlantla,
Mr. Liqhayiya, I'm sorry to interrupt. I didn't unmute myself. Just before you move off the first irregularity, your contention is that the applicant didn't appreciate the state's case in respect of his intention. But I'm wondering what you make of the summary of substantial facts, where in essence, the state's case is set out that the policemen did inform the applicant that they were police in seeking to apprehend him. And so is the applicant then not in a position where it knows that in effect, the state's case is you knew that we were police, and you had to then act with that knowledge. So in what respect did the applicant not appreciate that that was the state's case concerning his subjective state of mind?
My brother Justice Unterholter, before Mr. Liqhayiya responds, I'm just thinking that my sister Justice Mhlanhla's questions may be lost, as it were. May I just ask Mr. Ngubatobi to respond to those to a finish, and then
I beg your pardon. I'm sorry. I thought he'd answer.
Yes, because he was just starting to respond to my sister Justice Mhlanhla. Yes,
yes, the question is the test objective or subjective? We deal with this in our heads of argument when under the topic second ground of appeal against conviction, putative private defense. What we cite there, the judgment of the old appellate division in the Oliveira, where there is a distinction drawn between private defense and putative defense. The paragraph we've cited says the following: the test for private defense is objective, and to that extent, the judge is correct. Would a reasonable man in the position of the accused have acted in the same way? Then it says, in putative private defense, it is not the lawfulness that is in issue, but culpability, and that those two are crucial. If an accused honestly believes his life or property to be in danger, but objectively viewed they are not, the defensive steps he takes cannot constitute private defense. If in these circumstances he kills someone, his conduct is unlawful. His erroneous belief that his life or property was in danger may well, depending on the precise circumstances, exclude dolus, in which case liability for a person's death on intention will also be excluded. At worst for him, he can then be convicted of culpable homicide. So in a putative private defense case, what the focus is on intention. It is not the exclusion of unlawfulness, but intention in the sense of subjective knowledge that the conduct is wrongful. That is what the state ought to prove. So the judge seems to have misunderstood the test.
Sorry, counsel, could I just ask, is it confined to subjective knowledge, or is it moderated to some extent by the requirement that the subjective knowledge must be at least based on objective facts?
Yes.
If there's an absence of the objective facts, then the subjective knowledge cannot, as it were, win at the end of the day on its own. Because then
yes,
any person in that position would simply be able to rely on subjective knowledge disconnected from the objective facts.
Yes, no, that is correct, Justice Kolapen. In the judgment of Justice Majid, I think he wrote the judgment, Pistorius, he introduced the term rational basis for the subjective belief, which says that it must still be a sensible factual basis for the subjective belief. But nevertheless...
Sorry, it was Justice Leach, for what it matters.
Oh, yes. I think it's the other judgment that then you wrote an earlier judgment. But they introduced the phrase rational basis for the subjective belief. And so we would say that even if one accepted that as the standard, which is the rational basis for the subjective belief, there still needs to be facts upon which the belief is based. It cannot just simply be I say so, therefore it must be accepted to be the case. Let me come back to Justice Unterhalter's question, because there's also a risk that I will overlook that question. Justice Unterhalter, what my submission is on this topic is that if an accused says that my defense is putative private defense, in the same way as it happened in the Pistorius case, there has to be cross-examination on his state of mind. It needs to be put squarely to him or her that his state of mind at the time of the incident is incompatible with putative private defense. The objective facts that exclude his defense must be put to him. It must be said, you could not have rationally believed that the policemen, the two gentlemen, were not policemen on account of X, Y, and Z. And this is what the state, I believe, was trying to do at the end of its cross-examination. They were trying to cross-examine him on his state of mind when they were curtailed, because where that cross-examination starts, it starts by the prosecutor putting to him that Constable Makhalifa was wearing a bulletproof vest, but it does not say that the accused was aware that Constable Makhalifa was wearing a bulletproof vest. It does not even say that the accused knew that the bulletproof vest was written police. it does not even say that the accused knew or saw that there was a big writing on the chest of Constable Makhalifa. So even if you just look at that, you see the three defects where the state has been prevented from putting to him that you were aware that he was wearing a bulletproof vest, you saw that he was wearing a bulletproof vest, you saw that the bulletproof vest was written police, and therefore your subjective state of mind that you did not know that these two gentlemen were police is false beyond reasonable doubt. And we remember here that there were three crucial incidents where the police, on their own version, which was never put to the accused, were alleged.
Excuse me, Mr. Liqhayiya, excuse me. Perhaps I think the kernel of your case is where the court interrupted the prosecution from countering the evidence relating to whether Makhalifa and the deceased were police officers or not.
Yes.
And if that evidence has not been led,
yes,
the evidence of the appellant or applicant, as it were, remains unchallenged.
yes,
And if it remains unchallenged, my question to you is that an irregularity, or is that something that one can say that the state did not prove its case beyond reasonable doubt, mindful of the fact that right at the beginning of the trial, the applicant's defense was put forward that this is a putative defense.
yes.
And if the court prevented, as it were, the state from leading that evidence throughout the proceedings, the evidence of the appellant or applicant would stand unchallenged. And you would argue that a conviction based on the suspect. I'm not too sure about the label, whether you would call it an irregularity or not.
Yes, yes.
I'm having that problem.
Yes, yes. You know, Justice Matop, I must confess that I haven't considered the other consequence of my submission because I focused on trial irregularities, which would raise constitutional issues without looking at factual assessment as to whether or not the conviction was correct or not in the light of the irregularities. It may be that the matter doesn't stop at the answer I gave to Justice Mhlandla, that it's enough for the court to set it aside on the grounds of irregular conduct of the judicial officer. It might be that the other consequences that you find that the state did not prove its case beyond reasonable doubt, but that's not, it's always tempting to grab at something that appears to be a gift, but I've not considered that seriously.
Well, excuse me, the reason why I'm raising it, irregularity, it's more on a higher threshold.
Yes.
And it goes to the essence and the gravamen of the conduct of the court.
Yes.
But disallowing a question,
yes,
right or wrong, may not per se amount to an irregularity. But at the end of the day, when all the evidence is assessed and evaluated, one would sit back and ask oneself the question whether on these facts, did the state prove its case beyond a reasonable doubt or not?
Yes, that is true. We do say, though, in relation to ground 3 of our appeal, we do say that the state, in fact, failed to establish that the accused did not subjectively believe that the two gentlemen were policemen. When we analyze whether or not the requirements for a putative private defense were established. But the first thing I had to satisfy the court with is that the judge got the test wrong, because it's only within that net that you will be entitled to interfere. And I've tried to show in my answer to Justice Mhlandla that they got the test wrong, because the test for putative private defense is subjective. If that is the case, it seems to us then one needs to look at what were the bases on which the applicant believed in putative private defense and whether or not those grounds factually were established in this case. The one point that seems to be totally uncontested is that it was the deliberate intention of both Colonel Sithole and Colonel Makhalifa to be incognito. They did not want their identity revealed. And they had a good reason for it. It was part and parcel of Operation Fiela that they should be incognito in order to be effective. And that was a common cause fact. The second common cause fact is that they were driving a red Polo. They were not driving a marked vehicle. That again is completely common cause. The third common cause fact is that the accused had been robbed a year before in the same area. He had been robbed a year before in the same area. That coincides with the evidence of Colonel Makhalifa, who said that the Sunnyside area was notorious and riddled with crime. The fourth common cause fact is that when Colonel Makhalifa chased the accused, he took off his bulletproof vest and left it in the car, so that when he finally caught up with him, he was not wearing any identification. The fifth common cause fact is that he did not have handcuffs with him. And the sixth common cause fact is that they had guns with them. Now, when you look at all of those six common cause facts, they are all perfectly compatible with a version of a putative private defense based on the subjective knowledge of the accused. Now, there is another fact which is not common cause, but there was no cross-examination on, and therefore the court below should have accepted the version of the accused, which is that the accused reported the matter to the police himself. He volunteered his address, and he volunteered the facts of what had transpired. And again, there is another completely common cause fact that he went to at least two security officers. The first security officer said, "Why are your hands full of blood? I'm not going to help you." The second one said to him, "Stand behind me. When a police van passes by, I will stop it for you." And then on the last occasion, then he went to his place of residence and he spoke to his sister, and they agreed that they would report the matter to the police. And we also know on these facts, this is number 8, we know on these facts that Colonel Makhalifa could not identify the accused. He did not know where he lived. And the most probable inference to be drawn is that he was fetched at the address that he himself had given. So all of those 8 facts that are uncontested and undisputed are perfectly compatible with a putative private defense.
Mr. Nukatobi, can I come in here and say that all those facts that you make reference to are what may be regarded as peripheral facts, and they may nevertheless still be important. But the point you make is that it was never put to the accused that the police had told him that they were police officers.
Yes, it was never.
And while that may be so in the classical sense of cross-examination, if you look at page 23 of the record, Ms. Roos says to him, and that's at the bottom, just after line 20, "But you said then yourself, you asked them what you have done wrong, and the police officers told the court there was this discussion about where you got the laptop. They've informed you that they are police officers."
Yes.
So that's putting to him what the police had said in their evidence that they told him. He obviously denies that. So there's a difference in whether it was put to him as opposed to how the court ultimately evaluated that. And,
Yes,
and I take the distinction you make that the post-incident facts may well contribute to how the court should have weighed that particular crucial piece of evidence. But is it not so, at the very least, that it was put to him?
Yes, no, there is another. In fact, I started with both of his references. The one you referred to, and there's another at page 25, at line 9 and 10, where both of those propositions are made. My point is that if an accused says my defense is putative private defense, what needs to be put to him, according to the SARFU standard, is a direct imputation of what facts exclude the subjective state of mind of the accused. And it is those facts that the prosecutor tried to put to the accused that were curtailed. So one fact may be the police were wearing a bulletproof vest, which had a big sign on the front. The second fact is you saw them, that they were wearing this. The third fact is they told you that they were the police. The third fact, so all of those facts that would exclude the subjective intention, there should be cross-examination as to the state of mind of the accused. Now, this is what was prevented by the intervention of the judge. And the exercise can easily be compared with the record of the cross-examination, which is summarized quite expertly by Justice Leach. I wanted to give the credit to Justice Majid, but he denies the credit. But the comparison can be drawn easily with the Pistorius case, where there is a focused cross-examination on the accused's state of mind. Consider, for instance, at the time that the shooting occurred in the Pistorius case, that it is put to him that the so-called intruder, you had no information that they were carrying guns at all. In this case, what we know is that the two assailants, it was common cause that they were carrying weapons. And it was common cause that the weapon of retaliation was a small knife, which would be entirely proportionate with self-defense. Now, this is the point that we're trying to draw, that where it is outlined at the commencement of the trial, that my defense is putative private defense, it is an irregularity for a trial judge to intervene in a manner that makes the examination of that defense untested.
Mr. Mukatobi, may I just come in here, please? Pick up on one or 2 points and then ask a question of my own. Just on the last point of my brother Kolopin, that question where Ms. Rose is cross-examining the accused about when he was caught and he was told that these are police officers, he denied that. There's also the question of the language. Yes. Just help me, right? But one of the protagonists was Titswana speaking, the other one was Xhosa speaking. I think it was the accused who was Xhosa speaking. So there's the language issue there, isn't it?
Yes, no, he made it clear that he didn't understand. In fact, he repeatedly said they spoke in a language I didn't understand.
Yes.
The only thing he understood was when they said Wanyela. And he explained to the judge, because the judge got confused about that. He said, how did you understand Wanyela? He said, it's because we have the same word in Xhosa.
Yes. So help me, I'm not proficient in that language. That Wanyela could also be Sutu or Pedi, as I understand it.
Yes, it could be, the interpreter said it could be Tswana, Sutu, or Pedi. Yes. And then he said, but we also have the same word in Xhosa.
Yeah. Now, just coming to the question of what you were discussing earlier about the test as set out in De Oliveira, we know that for putative private defense, the test is subjective knowledge. And as you correctly say, point out, in Pistorius, this was the essence of the case, because ultimately what had to be tested was his subjective state of mind to probe into this private defense of his. Now, in this present scenario, if the accused subjective knowledge stands, but it is shown objectively on the facts, now that's an objective test, that belief that he had was not reasonable, he could still be convicted of culpable homicide, not so?
Yes, indeed.
But if it is shown that, in fact, on the objective facts, that belief is reasonable, then he must be acquitted completely.
Yes,
you can't be convicted of culpable. Thank you. Now, I don't know if you want to comment further on that, but I just wanted to clarify that. Here's my question. I have an antecedent problem, a more fundamental problem. How is this what we are discussing now about the test and how it was applied the law to the facts by Judge Baum. How does that engage our jurisdiction? I must tell you, I'm troubled not so much on the sentence, I can say in prima facie, but on the conviction. I'm troubled by the question of jurisdiction, bearing in mind that all we are doing here is applying the established law, De La Vera, Pistorius and others, on the facts of this case. Doesn't that fall foul of the jurisprudence of this court, I think in Busak and Jiba, which says the misapplication of established law to the facts that does not engage this court's jurisdiction? Help me here, please.
Yes, we say that the problem with the judge is a misunderstanding of the law. In other words, a proper articulation of the test. And I don't want to repeat the part, but it's been read out to the court by Justice Mhlanhla. This is not a case where the judge correctly understands the test, but misapplies it on the facts. It is a case where the judge misunderstands the test. And so that is a legal question as to what the correct test is. But we also say that because your jurisdiction is expanded on GPI, general public interest grounds, you have to set the test for putative private defense because you have not done so before. And it's clear that it's necessary for this court to express its view on that test because it's clear that that test is not understood. And in this case—
Hang on, Mr. Ngatobi, I'm so sorry to interrupt you, but isn't that an established test, as I said earlier? I mean, it may not have been established by this court, but there's no need to revisit De La Vera, Pistorius, and other cases of the SCA, or is there, and why?
No, we don't argue that. We haven't made that case that you should revisit the test. What we've said is you must correct the judge's wrong understanding of the test because the wrong understanding of the test has led to a wrong conviction. You should not allow a man to be convicted for murder and sent to prison for life in circumstances where there has been a failure of justice because the test has been incorrectly understood by a judge. So
in what way do you say it was incorrectly understood if the judge says that the test is subjective? In other words, what the accused had in mind objectively considered. Is that not a proper summary of the test?
Yes, let me just go back to page 3. Now, if you look at that, which is line 21, it follows that the accused defense firstly amounts to private defense, or more commonly known as self-defense, a defense excluding unlawfulness where the test is objective, and second, the putative private defense, which relates to the accused state of mind and where the test is objective. Now,
I'm not sure about that reference, but I'm looking at paragraph 8 of the judgment under evaluation, where the judge seems to have got the test correctly. The last sentence of that paragraph says the test is subject. Paragraph 8.
So which page of the judgment, my lord?
It would be typed page 6.
Yes, I've got page 6.
And the last sentence of that paragraph. It says the test is subjective. In other words, what the accused had in mind objectively considered.
Yes, I'm trying to find that portion. My judgment starts in the middle of the page. What is the page number in the middle of the page?
Just to help, I think it's paragraph 8, Mr. Ngatobi, yes. At page 6. Paragraph 8, my brother's referring.
Page 6, yes. I'm sorry, I think I've got it wrong because my page 6, line 8.
Paragraph 8. Paragraph 8.
Yes. Unless I go to, there's another version of this judgment also.
It starts with the paragraph. It reads, the accused version, as mentioned above, is that he acted in self-defense.
Yeah. My own judgment, I'm sorry about this, but my own judgment doesn't have paragraphs, it has lines because it's from the actual transcript.
Mine too.
Yes. Okay, I was just looking to see if my junior can help, but It's disappeared from WhatsApp.
I'm trying to help here also, Mr. Ngatobi. It starts with the subheading of evaluation.
Yes, mine doesn't even have subheadings.
Oh, it doesn't. Sorry.
So I've been working on the judgment that is just a typed version from the transcript of the court. And the test here is set out at page 3, from line 20 to page 4, up to line 5.
Why don't you read that, Mr. Ngatobi, for us to see if it coincides, the content coincides with what my brother Justice Kolapen was referring to?
This is where it says.
Could I be of some assistance? Maybe I've found another version of the judgment, but look, it probably is not the one you have. So sorry, because this one also has paragraphs, but it's at page 115 of my record, volume 2. But I don't know if that will help you.
Yes. Paragraph 115.
115, but I'm not sure if our numbering is the same because your earlier references, yeah.
It's not.
Okay, sorry. Okay.
Oh yes, my junior has printed for me the portion you were reading from. Could I ask the court if you have the judgment taken from the transcript, which I was reading from page 3, which is where the judge purports to set the test. Because it looks like there's a different version of the judgment that was put on Safli. And it may be that that the court is referring to the judgment that was put on Safli, which is different to the judgment that is that I'm using. It may be that what you are referring to, where there is a reference to S versus Trino.
Please read what you have, Mr. Ngatobi.
Yes. So firstly, on the test that is at page 3, this is what the judge says. It is common cause that the attackers were in reality 2 policemen on official duty. So those are the objective facts. It follows that the accused defense firstly amounts to private defense, or more commonly known as self-defense, a defense excluding unlawfulness, where the test is objective, and secondly, putative self-defense, which relates to the accused state of mind, and where the test is objective. The test to be applied in respect of the accused, he generally held it mistakenly believed that he was acting in lawful self-defense, or whether his belief was also held on should be reasonable grounds. It says reasonable doubts. So that's the first part. Then there is a later part.
That's our paragraph 5, Mr. Ngatobi, of our version.
Yes. Then there is a later part which I think that's what Justice Majid was referring to, which is in my judgment at page 10 at the bottom of the page, where the judge says, the circumstances to which I will return the credibility to the state's case, the criticism leveled at the state's case is that the state did not prove that where the accused got the laptop from and what happened to the laptop subsequently, and that it was never retrieved, is in my view of no consequence. And then he says, but that is not where the matter ends. The court has to consider whether the accused version is reasonably possibly true. But in view of the decision of the S versus Trino 2003-1 SACR 35 SCA, if the state's case is totally acceptable and unshaken, there is no rule for a finding that the accused version may be reasonably possible true. I will return to that issue. Then he says, in respect of the accused version, in considering the totality of the facts and holistically, as I have mentioned already, whether the version is reasonably possibly true, it is clear that his version is riddled with several improbabilities. As I emphasize that I have to consider all the evidence in totality. The court is not supposed to single out certain aspects of the evidence or the circumstances and rely on that for its decision. And then he sets out what the improbabilities are. So on the judgment we have, he never actually returns to the test. The judgment he read out in court, he never actually returns to the test, but then he completely dismisses the probability of the version given by the accused. So we would say perhaps then to answer the question more directly, regardless of which version of the judgment is being considered, it seems that what has happened is that there is another judgment that was loaded on Safli, which then has paragraphs, which is not the same as the judgment that was given in court.
Mr. Natubi, this is a critical issue, because I think the question of my brother Majid on the question of jurisdiction goes to the heart of your response. And if we have sort of different judgments that we are using as a point of reference, we can talk sort of past each other in good faith. And is there not a need for us to at least sing from one hymn, as they would say? And I'm not sure how we resolve that issue. Yeah.
Yes, well, I mean, the most reasonable assumption I can make here is that the judge gave one judgment in court, read it out in the record, and that is what we have. And then later on, he changed the judgment and published another judgment on Safli. That's the
Can I ask Mr. Liqhayiya, the passage that you've read from your version of the judgment, does the judge actually in terms refer to State versus Trainer, the SCA judgment?
It does.
You see, that worries me tremendously, because I've looked at this judgment again this morning. Nowhere does it refer in this version to State versus Trainer. So we have a fundamental problem, and I agree with my brother Kolop, this is a crucial aspect. We obviously working from two different versions, and I think you may be right that wasn't a judgment perhaps given extempore or given in court, and then thereafter a judgment was prepared with paragraphs, which is the one we've got.
Yes.
Yes.
That's the only inference I can make from this. That's why we have two different versions of the judgment. It's simply because, I mean, often it happens, but it shouldn't happen, especially if there's going to be a material change to the judgment. Could I then?
Mr. Liqhayiya, the judgment that you have before you, which is at pages 3 and 4 of the record. If we look at page 4, and this part is not in the judgment that most of the judges have before them. The last sentence, it says, the test to be applied in respect of the accused, he generally held the mistaken belief that he was acting in lawful self-defense, or whether his belief was also held on reasonable doubt.
Or reasonable grounds.
Yes. Could we say that the test as formulated in the judgment that was handed down extempore was that the test was subjective?
No. No, it's clear actually in the line before what you have read, Justice Terwa. It says a defense excluding unlawfulness where the test is objective. And secondly, putative self-defense, which relates to the accused state of mind and where the test is objective. And then he explains what he means by objectivity in the line that you've just read.
But his explanation as to what is meant by objectivity, he's actually stating the subjective test.
Yes. I mean, this is the problem actually, where we say that he is fundamentally, and I don't want to be too critical on this because it seems that he's produced two judgments. But if this is the judgment, then he fundamentally misunderstood what the test is. And quite apart from the understanding of the test, if you read the balance of the judgment, he never actually evaluates the accused state of mind subjectively by reference to objective facts. Never does that exercise at all. What he does is he accepts the version of the state in full, and he rejects the version of the accused in full, in circumstances where A, the subjective state of mind of the accused was never tested in cross-examination because he curtailed that testing. And B, the actual fact that the accused self-reported was never disputed by the state. And C, the accused version as to the identification of the policeman was corroborated by Mr. Nkuna.
But does that not go to the heart of sorry.
Oh, thank you, Justice Koppen. Before we go to how he dealt with the version of the accused, can we get some agreement as to whether both in the extempore judgment and the judgment that appeared afterwards, he properly stated the test. Now I know, and I accept, as you say, that in the extempore judgment, he refers to the test as being objective. But when he describes it in the sentence following that, doesn't he not describe a subjective test?
Yes, it's difficult to accept that, Justice Theron, because it's clear that what he's trying to do is to describe an objective test as he understands it.
Because he says it must be whether the accused believed he was acting in self-defense and whether that view was reasonable.
Yes, well, that too is actually not true on putative self-defense. The test, even if you accepted that, that would still not be the correct law. In other words, we become generous and we say he's trying to articulate a subjective test and that the transcriber got confused between objective and subjective. We come back to the heads of argument that we've submitted, where we cite the de Oliveira principle. And the discussion we have immediately below that to understand what exactly this test is. And that's probably one of the reasons why it's necessary for this court to opine on this. Firstly, we've quoted the extract there. Say, if the putative private defense is also reasonable, it excludes fault in the form of negligence, which is where we are, and therefore also precludes a conviction on culpable homicide. Now, that's the point that Justice Majid made with me, which I accept. But look at the next line. In this matter, it is submitted that the belief of the applicant was both genuine, excluding intention, and reasonable, excluding negligence. Now, on the first one, element of putative private defense, if the belief is only genuine, but nevertheless unreasonable, he is guilty of culpable homicide. But if the belief is both factually, subjectively held and also reasonably held, it then excludes negligence, which means you have not acted intentionally, but you have also not acted unlawfully, and therefore you are entitled to a complete acquittal. So even on that narrow understanding of the judgment, he still misunderstands self-defense because he is unable to disaggregate its two elements, that it is about where your subjective state of mind lands. The first one is a reasonably held subjective state of mind will also exclude negligence, and therefore you cannot be guilty of culpable homicide. But a genuinely held, in other words, rationally held, according to S versus Pistorius, will exclude murder, but it may still catch you on the net of culpable homicide. So even that test is a wrong articulation of the test.
Mr. Nkayitobe, just on that question as to the components of the test, a genuine but mistaken belief would exclude intention to kill,
yes,
as to culpability. There's one component of this, though, which I would like to ask you about, which is the requirement of proportionality. Does the belief that you have need to include the belief that you are acting proportionately to the threat that you face?
Yes.
That's the first question I would want to ask you. And even if you believe that you are acting proportionately, but objectively you are not, then presumably there would be negligence.
Yes.
Because one of the features in this case, which doesn't seem to have been considered by the trial judge, is even if the applicant's belief was honestly held, though mistaken, was his reaction proportionate to the threat he believed he was facing?
Yes. We accept, Justice Unterhalter, fully that proportionality is a feature of putative private defense. But it is a feature in the sense that it goes into the extent to which you believe your life was in danger. So, for instance, you use an automatic rifle to fend off a person who's threatening you with a pocket knife. It might show that your own state of mind did not genuinely believe that you were acting in self-defense, But because you have exceeded the bounds of proportionality, that shows that it was not genuine self-defense. In other words, there was no genuine and reasonably held state of mind. And therefore, you may be guilty of murder. But the point we make in this case is that there is no evaluation of his subjective state of mind in order to establish the two distinct elements of putative private defense. And that is why there is no evaluation as to whether or not his reaction is a proportionate reaction. But on the facts in this case, what we know is that he is faced on the common cause facts with people that are holding a gun on his version, which is disputed. They're trying to put him inside a car. He believes that they are kidnapping him. But what does he do in reaction to it? He is using a tiny instrument. It turns out to be an extremely dangerous instrument because it killed one policeman and it rendered the other blind. But
at that point, sorry to stop you mid-sentence, Mr. Liqhayiya, the hour is up. How much more time do you want? I know we interrupted you.
Yes, Justice Madlanga, I think the things I had to say on putative private defense have been said, and a lot has been covered in my heads of argument. I could just finish that sentence and then move on to sentence. Sentence and sentence. Excuse me.
An estimate. An estimate.
15 minutes.
Thank you very much. Thank you very much. Please continue with your response to my brother, Justice Matopo.
Yes. So just to say two more things, perhaps I should add an additional sentence. The first one is that if one accepted then the premise in the judgment that I have cited, it's still necessary for this court to correct the test, because even the articulation of the test in the type judgment that Justice Theron was putting to me still shows a material confusion about the two elements of putative private defense. In fact, it conflates them and it doesn't understand that the one excludes negligence and the other excludes only fault. And those are two separate requirements. And so because of that continuing confusion in the judgment, it's necessary for the court to correct it and also to set the test right in relation to the two components of putative private defense. It's not fair under Section 35 of the Constitution for a man to be convicted of murder because the judge Akwo misunderstood the test. It's necessary for the court to correct the test. Then,
before you move on to sentence, I think my brother Justice Matopo wanted to say something.
Yeah, I do. Thanks, my brother presiding. Mr. Liqhayiya, I don't want to leave this hearing with an uneasy feeling that the issue that was raised by my brother Majid regarding jurisdiction had not been squarely addressed. It causes me great discomfort, but I accept your argument now that says we have to find jurisdiction because a wrong test has been applied. But if one looks at the jurisprudence of this court, Jiba Busak cautioned us against finding jurisdiction where there has been a misapplication of the law. I'm saying this and echoing what my brother Majid put to you, that the test as stated in De Oliveira and Pistorius is still a test, and why should this court have jurisdiction purely to state what is the obvious? I just want to hear you on that.
Yes, I tried to make two suggestions in response to Justice Majid on that, Justice Matopo. The first proposition I tried to make was that it is not a complaint of ours that there has been a misapplication of a test. We say that there has been an incorrect articulation of the test. When the judge is wrong on the law, that is what the problem is. And in circumstances where you've got GPI jurisdiction.
Can I just stop you there, because for the purposes of my understanding,
Yes.
Please bear with me.
No, of course I have to.
If there has been a wrong articulation of the law, which results in a conviction and which has got no sound legal basis, and would you say then it impacts on a person's right to a fair trial in terms of Section 35. And if that's the case, you would invite us to have a look at that wrong articulation of the law, as the two judgments indicate that in one set, in the extempore judgment, the test is something else. In the subsequent judgment, there is another test.
Yes, that is true. But I do want to come back to Justice Theron's point, because what she attempted to do in her question is to reconcile the two and to say that in the first judgment, the extempore judgment, there was an articulation of a subjective test. But I tried to show that even on that generous reading, there is still confusion between the two components of the subjective test, and that the judge is confused about those as well, and that requires clarification. So in addition to what you have said to me, Justice Matopo, that is what I would add. I don't want the court to lose my entry point to jurisdiction, which is trial irregularities. Because once you have jurisdiction on trial irregularities, which is a classic constitutional question, then you have jurisdiction to correct the wrong conclusions of law that were made in relation to the articulation and the application of the test. But it should not be understood that I'm pinning my colors to the wrong application and articulation of the putative private defense test. My entry point to jurisdiction is trial-based irregularities. And you will not be overwhelmed. Yes.
Mr. Tobin, are you going to now summarize what your submissions were on trial irregularities? Because my discomfort arises from that point after you have had a debate with my brother Matopo on that. So when it's opportune for you to summarize what you said on trial irregularities, I'd like some clarification, please.
Yes. Well, there are two key trial irregularities. The court would have seen that the application for leave to appeal included the entire kitchen sink. We've abandoned those. The exchange between counsel and the judge seems to have been a fair exchange, robust exchange, and there was some impatience and perhaps impertinence, but seemed to be part of the game. But the two key trial irregularities that had an effect on the outcome in this case, the first irregularity was the curtailment of the cross-examination, where the issue of the subjective state of mind of the accused was about to be tested, but it never got tested. The second—
Now, my question arises from that, Mr. Liqhayiya, because I'd like you to make up your mind on this. During your debate with my brother, Matopo, you seemed to accept that if a version has not been put, a state's version has not been put, that would be to the advantage of the accused. And that if it is to the advantage of the accused, then when one assesses whether a conviction was correct or not, then one would have to take that into account in favor of the accused. Now, this is where my problem is. Now, once you make that concession, are you then saying that, in fact, what you are here for is to appeal against the conviction?
Yes,
it now goes to the whole issue around whether we now are faced with a vitiation of a fair trial right or an appeal against an incorrect conviction. That is where my problem is, because we need to know whether this is now an appeal against an erroneous conviction or whether it is a vitiation of fair trial rights.
Yes. No, Justice Chiko, it's clear that the appeal is against the conviction. What I'm simply saying is that the way to get there is that the conviction itself is tainted by material irregularities. This is not a case where I'm coming to the court and I'm asking the court overturn this conviction because the judge was wrong. I'm simply saying that the method of adjudication resulted in a failure of justice because there were material trial irregularities that vitiated the proceedings, resulting in an unsafe conviction. It is an unreliable conviction because it's been tainted by material trial irregularities. The point I wanted to make in conclusion.
If the state did not put its version to the accused, is that an irregularity?
No, if the state was prevented by the judge, it is an irregularity.
It is an irregularity to the disadvantage of the state or to the disadvantage of the accused?
Well, what we know here is that it ultimately worked to the detriment of the accused in circumstances where his actual version, his actual defense was never properly tested. So the key to the debate is the impact of these trial irregularities. And that is why I say that you will not receive many cases similar to this. You will not open a new frontier of criminal cases because there will be very few cases that are tainted by material trial irregularities, which you are duty bound to correct.
Mr. Liqhayiya, I just have one small thing to clear, if you don't mind.
Yes, yes,
it relates to this debate you're having about the approach of the court to his state of mind. There's a portion in the record where the state witness says, when we pinned him down, I asked him whether he thought he could outrun the police.
Yes, yes.
And he responded and said he didn't know that you were the police.
Yes.
We all know that that happened before the stabbing happened.
Yes.
Now, what I'm raising with you is this evidence by the state was not attacked in cross-examination, nor was it disputed. Does it amount to anything?
I'm not sure, Justice Mlambo, if it was not disputed in cross-examination. What I am sure about is that he was not cross-examined on that at all. And I can see where the wheels came off. It's when the state, because the first leg in the state's case was bulletproof vests, shouting and telling you, and then tripping you, and then telling you that we are the cops. Who do you think you are? Can you outrun us? I actually thought that part was put to the witnesses of the state.
I would appreciate if you could show me, because I thought I read the record. I read his whole cross-examination. I couldn't find any part where he was challenged on saying that.
The accused?
No, I'm talking about the state.
Mr. Makhalifa?
Yes.
Yes. So
it may amount to nothing, but I think it's something that must go into the assessment of his state of mind, as you say. Because
yes,
if that's correct, that conversation happened, then how do we then regard him going ahead thereafter and stabbing one and killing the other, and killing the other one and blinding the other one?
Yes. So the cross-examination on this part, it starts from page 57.
Yes.
But I remember specifically that the version was put of the accused to Mr. Makhalifa.
Yeah.
So it's at page 59, that's where they start. It's 58 of the typed up transcript, where Mr. Engelbrecht says, right now the accused will say that prior to the meeting with you people, him and his friend were in his flat. Then he says, I do not know, I was not there. Then, right, I'm just giving his version. And he says that after getting out of the flat building, that is when they encountered you people. Then he says, I would not say that they came out of the block, but when I saw them crossing across the road, he says, you see, and that is not where he encountered you people. It is not far from the entrance to Indwe. Then he continues, you see, said the accused will testify, if it need be, that there was no time for him to steal a laptop. There was a whole thing about the laptop, which no one ultimately found. Then he continues, that is correct. And I do not know if I have put it to you before. The accused denies that he was ever in possession of a laptop. He says that is not true. You go to the following page. And then at the point of the encounter, it is at page 59 of the record. Then he says, Mr. Makhalifa says, I was just behind the suspect because I'm the one that pursued him. I pursued him all along. And then he says, and that was near the polo. Yes, did you open the door to the polo? I do not understand the aspect of opening the door. I was in pursuit of the suspect on foot. The suspect was now tripped and he was on the ground, on the floor, on the cement floor or the tarmac. Yes. Were you with him? Yes. How far from the car? I'm estimating the distance about 4 meters. I accept that. The accused version will be, if need be, that one of you opened the rear door of the polo. Sorry, I do not follow. Then the one of them opened. Did you ask him where he opened? And then he says at page 60 in the middle. Then when he returned and the accused was laying on the ground, what stage did you open the rear door? It is at the time when the suspect was on the ground and I went to fetch the handcuffs. It is inside of the car. I did not hear the answer. The question was asked, I'm still interpreting, it goes on. The question, did you put or did you go for the handcuffs in the car? And to achieve that, did you have opened the door? Yes, they were inside the school bag. And then it continues. Now at page 61, towards the bottom of the page, he goes back to this. He says, you see, the accused version is that you were trying to put him into the car, and then he feared that he was either being kidnapped or hijacked. It does not matter. Then there was no way we could put him in the car. Then it continues, or he could be handcuffed inside the vehicle. And then the same, it continues at page 62. So it seems that the entire version of the accused was put to the police. So it's unclear where your lordship is headed with the failure of cross-examination on the accused part.
The point I'm simply trying to clear in my head is if that conversation happened and it was evidence of the state that when we pinned him down, I asked him, do you think you could have outrun the police? And the accused said, I didn't know you were the police. Then if the accused's defense does not challenge that the accused said that, does it not go to a state of the mind? Because the stabbing happened thereafter, after this conversation.
Yes, but it's clear he specifically, I mean, even in his own evidence in chief, even in his plea explanation, it's so clear that he denied that identification by the police because it was at the heart of the case.
I don't want to elaborate this further, Advocate Director. I just wanted to know whether it amounts to anything in our assessment, the failure to cross-examine the state witness on this, because I think it's somewhat critical that he said, I didn't know you were the police.
Yes, but it's the center of the defense that he put up, that he didn't know that they were the police. And it's, as I say, my own reading of the record is that it's quite clear that he always denied that there was any identification by the police. Could I move on to the last part of the appeal, which is the question of sentencing? The court has asked us to address the main...
Mr. Ngubetobi, I think in fairness to you, I'll start calculating the 15 minutes you asked for from now, because throughout we engaged you. So
Yes,
15 minutes from now.
Yes, Justice Madlanga, I'm indebted to that. My other problem now is that my computer is at 3%. So could I just get 30 seconds to switch on my computer?
Oh, okay, all right, all right.
Thank you, thank you. Yes, thank you. Hopefully, yes. Now the court knows that the statute, unlike before, sets out the so-called minimum sentencing provision, and it categorizes various offenses from which minimum sentences are to be imposed. One of those is murder, specifically murder of a police officer for good reasons. The question that often arises is whether or not on appeal, a court is entitled to interfere with the sentence because it believes that it could have exercised the evaluation differently, or whether or not the application of sentencing is within the discretion of the court, and any interference is to be on narrow and circumscribed circumstances. The judgments that have been referred to is Homarida and S versus GK. They both make it clear that a sentencing court, when applying the minimum sentencing provision, does not exercise a discretion in the conventional sense. Instead, it is a value judgment. It is an evaluation of the facts and the application of the law. Now, that flows from the judgment of the Constitutional Court in S versus Dodo, in which it was realized that the decision by the legislature to interfere in the sentencing powers of the court is a substantial encroachment to the powers of the court. And therefore, it is necessary for the courts to approach their sentencing power with the Constitution in mind. So we say, point one, you have to take into account that the function of sentencing in minimum sentencing provision is a statutory function. And because it is a statutory function, it is constrained by Section 12 as well as Section 35 of the Constitution. So if a court of appeal encounters a sentence that is disproportionate in the light of the facts, it is open to a court of appeal to impose a different sentence and not to consider itself as bound slavishly, because it is the exercise of discretion. Although the court has referred us to Hamorida and S versus GK, there is also a judgment of the Supreme Court of Appeal by Judge Bosiello in Bailey versus the state, which endorses the principle, and we've cited this at paragraph 16 of our supplementary heads. Because of its significance, it's necessary to read it out, the passage in full. It's at paragraph 21, where this SCA specifically paid attention to this problem of sentencing. And it says, the most difficult question to answer is always, what are substantial and compelling circumstances? Because that's the statutory entry point to the departure from the prescribed minimum sentencing. It says the term is so elastic that it can accommodate even the ordinary mitigating circumstances. Then he says, all I am prepared to say is that it involves a value judgment on the part of the sentencing court. And then when he applies that, which is at paragraph 22, he says, reverting to this appeal, the question to be answered is whether the majority of the court below erred in failing to find that the circumstances in this case were so substantial and compelling as to justify a departure from imprisonment for life. Then there is a further judgment, S versus Taffin, that came from the Western Cape High Court, which approves Homarida and follows the Bailey judgment. And it makes it clear that the imposition of a sentence under the minimum sentencing provision, and specifically the consideration of whether there are substantial and compelling circumstances to depart from the prescribed sentence, is not a discretion. And because the court specifically says at paragraph 4 of that judgment, which we've cited at footnote 14 of our supplementary heads. However, the exercise of a narrow discretion is not involved in the making by a sentencing court of a finding, because it is a finding of the effects in terms of section 51(3) of the Criminal Law Amendment Act of 1997. That is, or is not satisfied that substantial and compelling circumstances exist which justify the imposition of a lesser sentence. And then it says, while the range of relevant circumstances falling to be taken into account in making the finding in the given cases will, in the nature of such matters, necessarily be disparate and incommensurable, there is not a range of equally permissible options available to the decision maker. The court is either properly satisfied as to the existence of substantial and compelling circumstances, or it is not. So this is now the fourth judgment that makes the position quite clear. But we also ask you to have regard to a judgment, in this case, now written by Justice Majid. I initially credited him with Pistorius, which is Mudau versus S, which is in fact an instructive judgment, because although that case was not about murder, what it was about the imposition of life imprisonment for a person who was guilty of the rape of a minor, which is a category of offenses that fall under the minimum sentencing legislation. And what he says, which is the instructive part, which we cited paragraph 19 of our heads, what the court there says, life imprisonment is the most severe sentence which a court can impose. It endures for the length of the natural life of the offender, although release is nonetheless provided for in the Correctional Services Act. Whether it is an appropriate sentence, particularly in respect of its proportionality to the particular circumstances of a case, requires careful consideration. And I would say that requirement for a careful consideration applies even more so in a court of appeal that is intended to correct prior irregularities and also intended to change disproportionate sentences. And then he says a minimum sentence prescribed by law, which in the circumstances of a particular case would be unjustly disproportionate to the offense, the offender, and the interests of society, would justify the imposition of a lesser sentence than the one prescribed by law. And in that case, the judgment was that they had to overturn the judgment of the court below because it had erred. It was not a question of exercising the discretion and therefore not being entitled to interfere because there is a narrow discretion to be exercised. So we say you have 5 authorities. You have 3 high court judgments, 2 of which have been full benches. You have 2 Supreme Court of Appeal judgments, which are actually quite authoritatively and powerfully written, which repeat the same proposition that you should not enslave yourself to the idea of discretion. Rather, you should consider your function as to applying the law in the light of the Constitution, because one must face it. Life imprisonment is quite a tough sentence. So we therefore submit that in the light of these 5 authorities, it's clear that the way the law has developed on this topic is not to regard the imposition of a sentence under the minimum sentencing provision, and particularly a judgment on the question of whether substantial and compelling circumstances exist for a departure. It has not been to regard that as a matter of discretion of which your powers to interfere are limited. It has regarded it as classified it, as we put it in our heads, as a value judgment in which you are at large to interfere if you think that the sentence induces a sense of shock and is disproportionate.
Mr. Ngulatobi, if we are not with you regarding the fair trial irregularities and that we don't agree with you that we have jurisdiction in respect of that ground, and if we also of the view that what this case involves is a misapplication of the law, it is settled in this court's jurisprudence that jurisdiction is founded on the pleadings. Now, the applicant has not pleaded the point that was raised by the court mera moto in respect of sentence. Can this court found jurisdiction on a point that is mera moto raised by the court and is not raised on the pleadings? And if so, how would we reconcile that with Qaba? And how do we prevent future litigants from saying, well, where we have not properly canvassed jurisdiction on the papers, the court should carefully look at the papers, and if there's any point on which it could found jurisdiction, then it has a duty to raise it. Mera moto.
Yes, Justice Teron, there is a recent judgment that the court delivered. It's in Mediclinic. I'm not sure if the court will follow Mediclinic for the future, but Mediclinic is an interesting judgment because it explains, in fact, it's a judgment of Justice Mogoeng. I don't know if there was a dissent or whether it was a unanimous judgment.
There was a dissent.
Oh, yes, indeed. Of course, there was a dissent. Yes, how could I forget, especially talking to the person who authored the dissent. But the finding that Justice Mogoeng makes in that judgment is that the jurisdiction on the GPI jurisdiction, it depends on whether an issue arises from the papers. And I think that's the word he uses, that if the issue arises from the papers, and he, I think, specifically says, it doesn't actually matter if it's been specifically mentioned by one of the parties. It arises, if it arises on the papers, then the court is duty bound to address that issue and to assume jurisdiction on that issue. I will find the paragraph. In fact, I think, Justice Teron, it's on that point that you dissented. But nevertheless, that seems to us to be the law in Mediclinic. So that's the first answer to the question. But there is a second answer, which is closer home. The problem here is that it's the same point you made, I think, in Mulaudzi, that if there is an irregularity, whether it is an irregularity of sentence or an irregularity of conviction, that cries out for the intervention of the court, it's in the interest of justice that the court should intervene. And that's I think it was Mulaudzi versus the state, a case which had to balance the questions of finality as well as the necessity to act in the interest of justice. So on those two judgments, we would say that if on the evaluation of the papers, the issue arises, and when you look at the significance of the issue, you come to the conclusion that it is in the interest of justice to intervene, then you should. We ask you not to allow form to override substance. It is not as if anyone has been prejudiced by the issue arising, because the facts are there, they are not going to change. The only question is whether or not there is any prejudice, but there isn't prejudice. We are all debating a legal point about.
If Mr. Liqhayiya, the court was inclined to adopt the route that you propose, how would we reconcile that with our jurisprudence in Kaba?
Yes, Kaba was a case, well, now recently, Baloyi, was a case in which the court said that jurisdiction is established by the pleadings, in the sense that, but this was a choice between the jurisdiction of the High Court versus the jurisdiction of the Labor Court. That if a party pleads a case that falls under the jurisdiction of one court, that is an issue that must be taken into account. But that is a different issue to the assessment of whether or not an issue falls under your GPI jurisdiction, which you have already made rulings to that effect on Mediclinic, and have made rulings on Mulaudzi. So it doesn't seem to me, or at least to us, that you will have to depart from Daba. It's perfectly compatible with Daba that if you are to choose between two forums, whether or not to go to the High Court or to the Labor Court, which was Daba and now Baloyi, in order to make a choice about which of those two forums, you have to look at which case has been pleaded by the applicant. In fact, that was the same point made in Makhanya versus University of Zululand. So that's one line.
Mr. Liqhayiya, we're not talking about the fora to choose. We're talking about invoking the jurisdiction of this court, and that it must, and Kaba says, we look at the pleadings to determine whether or not the court has jurisdiction. And that was confirmed in Jiba.
Yes.
And it's common cause that the question of sentencing and whether it's a value judgment or not, entitling this court to interfere, was not pleaded by the applicant in this matter.
Yes, but it is a legal question that arises from the common cause facts. I mean, and you are entitled to decide a legal question if there is no prejudice. And you have given us an opportunity to address you, and we have addressed you. Justice Nobos did say many years ago that if there is a legal question that arises from facts that are common cause that does not warrant a resolution of controversial facts, you are duty bound to decide it if it causes no prejudice. But it doesn't cause any prejudice. In fact, if you don't decide it, you will exacerbate the prejudice because you will let a person stay in prison for life because you are not intervening when you should, in the interest of justice, intervene. So we would submit, sorry.
Sorry, I wanted to just ask you one other question, not on this line. So if there's something more you'd like to say in response to my sister, please do so.
No, Justice Untitled, I would be repeating myself.
I wanted to just raise this question of the value judgment in contrast to the discretion, because the issue that then arises is if the conclusions that are reached in respect of substantial and compelling circumstances is a value judgment rather than an evaluation of all the relevant facts, I'm wondering what you consider the right test for appellate intervention to be. Is it a significantly disproportionate sentence? It's surely not every single error of evaluation that would trigger appellate intervention. What's the standard for intervention, assuming one accepts that it's not a sentencing discretion in the narrow sense?
Yes, we would commend, and I mean this in all seriousness, we would commend the test proposed by Judge Majid in Modau versus State versus Modau, because what he says there, he says whether it is an appropriate sentence, particularly in respect of its proportionality to the particular circumstances of a case, requires careful consideration. A minimum sentence prescribed by law, which in circumstances of a particular case would be unjustly disproportionate to the offense, the offender, and the interests of society, would justify the imposition of a lesser sentence than the one prescribed by law. So
does that mean that although two reasonable judges may come to different evaluations of the question, if the evaluation is unjustly disproportionate, that's what would trigger?
Yes.
So you would recognize that you could have two different evaluations, which one may be harsher than the other, come to different conclusions, which wouldn't trigger intervention. But if the net result is unjustly disproportionate, then it would.
Yes, that's the approach we would support. I mean, he actually explains why that is so, because he says in circumstances of life imprisonment, then you have to look at the proportionality. And that proportionality will then become a question of judgment. But what's clear from what he suggests is that you shouldn't regard yourselves as constrained by exercise of discretionary power. But what standard you apply in interference, we would submit would be a standard of evaluating the proportionality in the circumstances of a case, which would then still largely leave lower courts able to play a sentencing function without the fear that there is a bigger court constantly trying to second guess what they do.
Mr. Ngotobi, how would such a test of unjust disproportionality differ from the ordinary test that an appellate court would apply in cases where the minimum sentencing legislation was not underpinning? Would that not then really mean that the test would be the same by and large in two separate instances that we sought to distinguish?
No, I would submit, Justice Colopen, that, I mean, I suppose there are two extremes. The one extreme is whether each and every irregularity in sentencing entitles a court of appeal to interfere. The other extreme is a narrow discretion where you are not allowed to interfere unless you can show material irregularities. And somewhere in the middle, and that is probably the intervention sought to be achieved by this discussion, and somewhere in the middle is a careful calibration of a graduated form of intervention, so that it's not a free-for-all, but at the same time, you are able to correct patent and manifest injustices. But the way to correct those patent and manifest injustices is firstly to do away with the classification of discretion versus a value judgment, and to fix yourselves firmly on the side of value judgment. And then thereafter to debate what should we do on a particular set of facts. And what we say is clearly correct is the proportionality standard, in order to avoid the risk that each and every sentencing error then falls into your jurisdiction, because you can imagine what will happen if you took that approach.
I worry, Mr. Mugaitobi, when you continue to refer to irregularities, because you've now said that any irregularity in sentencing is your case that in the sentencing itself as well there was an irregularity, or are you saying that there was an error? Because you now said that you now refer to an irregularity in sentencing.
No, I don't say that. I mean, if I use irregularity, it was a very loose deployment of language. I apologize. What I am talking about, is that a mistake in sentencing, or a wrong sentence, which nevertheless is not disproportionate, in the sense that you look at the sentence, you say, I would have arrived at a different sentence. That's not the standard we are proposing. What we are asking the court to look into is whether in a particular set of facts, a judge below has slavishly followed minimum sentencing without applying a proportionality standard. If they have done that, you should not be constrained by the exercise of a discretion. You should interfere on the basis that this is a value judgment that they are exercising. So if I use irregularity in that context, it was my error, and I withdraw it.
Mr. Mugaitobi, on the two convictions, the murder conviction, we know that the court found that there were no substantial and compelling circumstances.
Yes.
If we are with you on that one, and we find that it should have found that there were,
yes,
then there will be a basis for us to interfere and impose a lesser sentence. What is the position in respect of count 2, the attempted murder charge?
What we have said in the main submissions on that issue is, firstly, those should have been treated as facts arising from the same incident.
But the issue of compelling and substantial circumstances, it does not arise on that one, does it?
Oh, yes, no, yes, I agree.
There's no.
Sorry, I misunderstood the question. Yes, indeed.
Now, if that is the case, what would be the grounds for us to interfere in respect of that particular count?
Oh, yes, it would be the fact that there are, in any event, strong mitigating factors in the conventional sense. There are strong mitigating factors. What you have is a shockingly inappropriate sentence. Yes, so that would still justify an interference to impose a lesser sentence on the second offense. Of course, you cannot treat them as if they are treated by, they are classified under the minimum sentencing legislation, because they are not. But it would still be a shockingly inappropriate sentence, the imposition of 15 years in relation to the second offense. But there are strong mitigating factors in this case. I debated with the court at the beginning at length the context of the trial.
Mr. Mugaitobi, let me just ask you something before you move on to that. Malchus tells us that life imprisonment can be imposed in terms of section 51(1) if it's not a sentence that is unjust. In other words, if you sit back, taking the circumstances of this case, and ask yourself, do the circumstances merit a life imprisonment? If you find that it is unjust, you would be entitled to interfere as an appellate court.
Yes.
Secondly, when you look at the sentence that, the provisions that gave the court jurisdiction to impose life imprisonment is the section that deals with where a law enforcement officer has been killed.
Yes.
Now, I just want us, you and I, to focus on that. If we think about, or we try and second guess the intention of the legislature, is that intention for these exigencies, this set of circumstances where the accused says, I don't know that you're police officers. I didn't hear you. You were not wearing significant clothing for me to identify you that you are law enforcement officers. So whatever happened at that time, I didn't know that you were law enforcement officers until the stabbing, subject to the qualification that my brother Mlambo put to you about shortly before that time. Now, I want to posit this scenario, and you tell me if you agree with me or not. I would think the intention of the legislature was to curb violence or killings perpetrated against police officers, not in these similar circumstances.
Yes.
In circumstances, if one were to think about your cash in transit situation, where police officers would face the full fire from the criminals, but not Mr. Tuta.
Yes.
And if one were to invoke that provision and say, because I have found you guilty for killing a law enforcement officers, therefore, boom, you have satisfied the requirements. Absence, substantial and compelling circumstances, I give you life imprisonment.
Yes.
I have a problem with that.
Yes, yes. In other words, Justice Matopo, it is the mechanical application of the statute that gives rise to unjust outcomes, because it's not the judicious application. I mean, obviously, all murder of anyone is wrong. Obviously, all murder of any law enforcement officers is wrong, and society rightly should show opprobrium for such. However, not all murders are the same. And so if one approaches every murder of a law enforcement officer through a mechanical evaluation, you are always bound to come to an imposition of a life imprisonment. But that is to take away a judicial function, which is to make an evaluation about the circumstances in which the murder occurred, and to decide on the evaluation of that murder, what would be an appropriate sentence. What we are concerned with in this particular case, we are submitting is the concern in this particular case, is the apparent slavish adherence. The circumstances of the offense are just dismissed, completely dismissed. So it's the mechanical and the slavish nature in which these sentences are imposed that the court needs to intervene. And in fact, this is not the first time this point has been made. The SCA makes the point all the time, and most recently in the S versus Modao case, it was there in the context of rape of a minor, in which it says rape, of course, is a serious offense, and because it violates the personal and bodily integrity of a victim. But to simply say that all instances of rape are the same, and therefore all of them should be visited with life imprisonment, is a mechanical application of the law and takes away the judicial function. So your question, Justice Matopo, is in fact spot on, that what we are asking for is a judicial application of the mind to each and every case. The one point, though, about the qualification that you mentioned of Justice Mlambo, that qualification doesn't go into the cross-examination of the accused on his state of mind, because even without qualification, the concern still remains that there is still an irregularity in the cross-examination of the accused about his state of mind. So we would say in this case, you should find that there are substantial and compelling circumstances that justify the imposition of a sentence lower than life imprisonment. the most powerful of these circumstances is the conduct of the accused subsequent to the event. The judge criticized unfairly the accused and said to him, he didn't go to the police station because he knew that he was guilty. He had a motive of trying to hide what he had just done. But that just was in conflict with a common cause fact that he did, in fact, report himself to security officers and that he wanted to go to the police station, and he was only able to do so the following day. He was fully cooperative with the police. He made all of the
Mr. Ngetobi, I assure you that we have,
yes.
we do take into consideration all the mitigating factors that have been set out in your written submissions. Is there anything else you wish to say?
No, Justice Madlanga, because I was only going to deal with the mitigating factors, but they are all carefully set out in our heads and in our supplementary submissions.
Justice Madlanga, with your leave, if I may pose a question relating to count 2.
Yes.
Thank you. Thank you.
Yes.
Mr. Liqhayiya, this court raised the question of compelling and substantial circumstances in the directions that we issued. Those relate, the submissions that we received, well, the directions and the submissions we received relates to count 1. The sentence in respect of count 2 does not appear to be covered broadly in the pleadings or in the submissions. Would the respondent have been on notice that the applicant seeks a reduction or interference from this court in respect of count 2? And has that issue been properly ventilated?
We would say that, the issue, there are no additional facts to be canvassed on that issue. It's fully before the court.
I'm sorry to interrupt you, Mr. Liqhayiya. We are dealing with the legal question relating to count 1.
Yes.
And the submissions related largely in respect thereof.
Yes.
Was there any indication or any pleadings from the applicant to alert this court as well as to the respondent that the applicant claims that the sentence in respect of count 2 is disproportionate?
Yes. Justice Teron, I will look into that issue specifically, but the submission I was trying to make was that if you, what we submitted in our original heads of argument from paragraph 83 was that there was a problem in not considering these 2 sentences in relation to their cumulative effect. And we also submitted that there were strong mitigating factors, and there were in fact no aggravating factors. And even that sentence of 15 years rather, is an unduly punitive sentence in relation to the second count. And so it seems to us that they would have been on notice that both sentences are challenged. And they have in fact argued why there should be no interference with the sentencing. But there is also another factor to be taken into account, which is the utility of this exercise. A court is engaged with this matter. Theoretically, it finds that it has no jurisdiction in relation to the conviction. And it also finds that it has jurisdiction in relation to sentencing. But it seems to us to be an artificial split to then decide only the minimum sentencing part of it and not decide another issue that is squarely before it, which is the issue of the other sentence, the second count. I would just want to look at paragraph 74 of our heads of argument, because I think that issue is actually squarely addressed in paragraph 74 of our heads of argument, without any protestation that it has been wrongly inserted into the debate. Yes. So yes, in fact, there it is. At page 31, paragraph 74. We say the High Court's reasoning justifying the 15-year sentence for count 2, attempted murder, is thin, but the court seemingly relied on the same analysis of mitigating and aggravating circumstances. So it was precisely the same reasons that were used in relation to finding that there were no substantial and compelling circumstances to justify departure. That was then used to justify the 15-year sentence. And from there, 75, 76, 77, we addressed all of those, including the case that Justice Matopo has raised of Malchus. So it seems to us that it would be, with respect to an artificial split for the court to decide one part of the sentence and engage its jurisdiction on that part and then reject its jurisdiction in relation to another part of the sentence. Justice Madanga, I have exhausted my submissions with respect. Thank you very much for the time.
Thank you, Mr. Ngugay-Toby. The court will adjourn and resume at 12:12, 12 minutes after 12. Court adjourn.
Court will adjourn until 12 o'clock. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin the video and sound when the hearing recommences at 12 o'clock. Should you exit, you may use the same link to rejoin the hearing.
Is my brother Justice Matopo with us? Thank you. Thank you. Yes, Ms. Rakudu.
Justices of the Constitutional Court, all counsel are online.
Yes, Ms. Schwartz.
I just want to know, can the justices see me? I'm not sure from my side.
We do, we see you.
Thank you so much, Justice. Then I will proceed with my address. As I will address the court on the points already argued with the putative self-defense, the fair trial, the discretion versus the value judgment, as well as the application of that on the facts. The putative self-defense, it's my submission that the test that was applied in S versus de Oliveira is still the test, the objective test. And there was quite a discussion about what Judge Bang said in his judgment regarding the objectivity of the test. If I remember, it is page 3 of the judgment, page 164 of the record, paragraph 21 to 23, and he proceeds on page 165, paragraph 1 to 5. And if I can quote from his judgment, he said the test to be applied in respect of the accused, he generally held it mistakenly believed that he was acting in lawful self-defense, or whether his belief was also held on a reasonable doubts. And furthermore, on page 9 of the same judgment, page 170 of the record, that will be paragraph 12, he said, I have already mentioned that the accused defense amounts to putative self-defense. He was of the mind that he was entitled to react against the attack, not knowing that the men were policemen or assailants. My submission is that the court not only applied the objective test, but also look on the subjective side of it. What was the subjective mind of the applicant in this matter? And then for any court to adjudicate whether the accused person's act of putative self-defense is justified depends on a holistic examination of the facts before the court. And the evidence as such is that the applicant was chased by the 2 police officers, Constable Liqhayiya and the deceased. And Constable Liqhayiya testified that before the applicant was arrested, he shouted at the applicant, "Stop, police," and "Police, stop, otherwise I will shoot you." Then Constable Liqhayiya said after the applicant was pinned down, he asked the applicant the following: "Do you think you can outrun the police?" And Constable Liqhayiya presented his appointment certificate to the applicant when the applicant indicated that he did not think them to be police officers. And furthermore, Constable Liqhayiya pointed out in cross-examination that the bulletproof vest that he was wearing was embroidered with a police insignia, which is reflective at night. The police officers inquired from the applicant why he was running away. If he did not know they were police officers, the applicant could not give an explanation why he was running away or whose laptop it was. The witness then went on to testify how he informed the applicant on the charges against him. And the applicant also did not inform the police officers that he thought them to be robbers. Neither did the applicant request that any of the 3 security guards to call the police for him. He respectfully submitted that objectively looking at the evidence, the applicant did not act in putative self-defense. He humbly submitted that the court-acquires conviction was correct in this regard. So my submission further is that the applicant knew at that stage that this was 2 police officers. And furthermore, there wasn't a language barrier as the applicant wanted the court to believe, because, as we know, he's an LLB student. And furthermore, there was a conversation in English between Constable Liqhayiya and the applicant, and it was never denied by the applicant that he had this conversation in English with Constable Liqhayiya. Then the second point about the fair trial is in the case of S versus Theory, a 2021 decision. The court stated that the test is always whether the trial in itself rendered a fair opportunity to the accused person to present his case. In this matter, the applicant was aware of the charges against him. It was read out to him in court. The summary of the facts was also read into the record. His counsel was granted an opportunity to cross-examine the state witnesses. The applicant testified himself and also called a witness. And yes, there was some discussions between the counsel for the applicant and the presiding officer, but the counsel for the applicant indeed has a hearing impairment as well as an eyesight problem. And this is clear from the record. We can see that at many times the court personnel was requested to repeat themselves. My submission, if the counsel of the applicant wanted to elevate his complaint regarding the presiding officer, he had the opportunity and the resources to approach the applicable authorities, and which he elected not to do. It is respectfully submitted that the discussions between the presiding officer and the counsel for the applicant did not have any bearing on the applicant's rights to a fair trial. So my submission is that the test in S versus Theory was indeed applied. And there's the discretion. This is the value judgment. It is common cause in this case that Section 51, subsection 1 of Act 105, 1997 was applied by the court a quo as the deceased was a police officer. And then Section 51, subsection 3 of the same Act allows a court of first instance to deviate from the prescribed minimum sentence if substantial and compelling circumstances exist. Now, we know all that there was no rules laid down as yet to what substantial and compelling circumstances have to consist of. So thus it is up to a court of quo to find a balance, keeping in mind the personal circumstances of the accused person, the seriousness of the offense, the interest of the community, as well as Act 105 of 1997. And the question was then directed to the parties whether Section 51, subsection 3 of this Act grants a court of law a discretion, or is it a matter of value judgment? And then in the cases S versus Omerida and S versus GK was compared with each other, and it was to be found that S versus Omerida remarked that Section 51, subsection 3 grants a court of law a discretion when deciding if Section 51, subsection 3 is applicable or not. But when a court decides upon the weight that has to be attached to the substantial and compelling circumstances to conclude an appropriate sentence, the court has to make a value judgment based on the facts of the case and other information presented to the court by the state and the accused. And in S versus GK, the court differed and stated that when deciding on whether substantial and compelling circumstances exist, it's not a discretion the court has, but a value judgment exercised by the court. This in itself creates an uncertainty in the approach to be followed, which provides the Honourable Court the opportunity to intervene and create legal certainty. In the application on the facts, Bam J, as he was then, was clearly aware that the starting point was Act 105 of 1997. The court of work considered the personal circumstances of the applicant, especially his age, and the fact it was a first offender as a substantial and compelling circumstances. The court also remarked on the fact of remorse as the applicant did not show any remorse, but the court expressed clearly that the applicant's lack of remorse would not be held against him. The court correctly considered the seriousness of the crimes that were committed. The crime, namely the murder of the South African police member, is viewed to be of such a serious nature that the legislature specifically made provision for this sort of crime under Section 51 of Act 105, 1997. From this starting point, being life imprisonment, the court exercised its sentencing discretion to consider the presence of substantial and compelling circumstances. In doing so, the court exercised a value judgment by considering the specific circumstances of the case and found that the personal circumstances of the applicant, which was raised as substantial and compelling circumstances, was outweighed by the aggravating circumstances surrounding the commission of the crimes.
Ms. Ross, the 10 minutes is up. May I ask to understand your argument on conviction? You straight away zoomed in on the facts, grappled with them. I'm not sure at what level of the matter you were doing that. Are you accepting that we have jurisdiction, and with that acceptance, then trying to counter the argument of the applicants on the factual issues they addressed, or is that not the case? If so, at what level were you grappling with the facts? I just want to understand you.
Justice, the view is from, or my submission is that this court has the power to interfere with the sentence.
No. Before we get to sentence, I'm going back to conviction. Yes, under conviction, you dealt with a number of facts, why runaway, there was no language barrier, and so on and so on. So what I want to understand is where exactly were you in terms of the issues that have been raised by the applicants? What were you addressing exactly, and how do facts feature in whatever it is that you were addressing?
My Lord, Justice, if I understand it correctly, this all goes down to whether a fair trial was received by the applicant himself. And there was arguments raised then of the objectivity, the test as an is versus the Oliveira. And my submission in that regard, if one looks at the facts of what was the evidence itself, it is my submission that the court applied his mind in deciding whether there was a putative self-defense or not. So my submission is that in that regard, the applicant received a fair trial as the court properly applied his mind. So that conviction was correct.
I must say that the very first question that was put by my brother, Justice Matopo, to Mr. Liqhayiya went to the correctness of the conviction. And Mr. Liqhayiya's response, perhaps quite understandably, was one of, I'm sure you know the expression, Timeo Danaios et donas ferentes. I fear the Greeks when they come bearing gifts. Mr. Liqhayiya said, yes, that's a wonderful gift, but unfortunately, that's not the case we have presented to this court. But the short point I want to make is that, of course, my brother Justice Matopo was posing it as a question. He was not making a statement, but speaking for myself and along the lines of that same question, I believe, subject to what you will say, I believe that Mr. Tuta was wrongly convicted. The judge just proceeded from an assumption that police can never lie. Police always act lawfully, and that's quite central to the probabilities that the judge then grappled with. It's quite central to that. But as Mr. Ngcukaitobi said, question is, are we able to go there, you know? And we can only revisit the conviction if we are able to say, here is a constitutional basis for doing so, or here is a basis founded on our general jurisdiction to do so. So it's one of those cases, in my view, that are quite unfortunate. I strongly feel, but again, I say subject to whatever you may say, and to the extent that it may be relevant for you to say anything at all, but I strongly feel that the judge got it all wrong, and all of it had everything to do with the attitude that he adopted. Anyway, please continue with your submissions.
Justice, in that regard, I want to submit that if one looks at the facts, at the evidence itself, take away that he went, there's the submission that his approach was that the police can never lie. Look at the evidence before court. The evidence is that there was communication between the Constable Liqhayiya and the applicant.
Justice Madlanga, if I may try to assist to get the question answered that you have posed. Ms. Roos, if I could refer you please to section 167 of the Constitution. 167, subsection 3B. And it relates to the jurisdiction of this court. This court may decide constitutional matters and any other matter if the court grants leave on the grounds that the matter raises an arguable point of law of general public importance. Now, the question from the presiding judge is, does this matter, the conviction, fall into the ambit of section 1673 B1 or 2? What are your submissions in connection therewith?
Justice, my submission will be that this does not fall within the jurisdiction of this court, because when we look at the facts, it's a question of whether the law was correctly applied to the facts and not whether it is a constitutional matter. So my submission is that it does not fall under the jurisdiction of this court.
Mr. Ngcukaitobi's submission is that the fair trial irregularities, as he refers to them, raises a constitutional issue. What do you say about that?
Justice, my submission is he received a fair trial. If, for instance, the argument that the state was curtailed by the presiding officer in cross-examination, and that is not giving the applicant a fair trial, is not correct, because in that matter, the state only wants to put the version of the state to the applicant. The applicant made his subjective mind, and the argument around that, he informed the court of that. So my submission is that will not curtail the fairness of the trial.
Please continue, Ms. Roos. With your own submissions here.
My submissions, my last point of my submission was that it's the respondent's respectful submission that the standard that should be applied should an appellate court be of a different view be the test of gross disproportionality as per S versus Dodo.
Ms. Rose, to what extent was the applicant questioned about his state of mind, the subjective state of mind in relation to the defense that he had raised?
Justice, in that regard, yes, that is indeed so that the state was curtailed in some sort of way by the court when it was busy cross-examination, but I must submit that that didn't have influence on how the state or what the state asked this applicant about the state of mind. Because I must admit it was already clear from the cross-examination of the state witnesses that what was the state of mind of the applicant. And my submission, sorry, Justice.
Now I was going to ask you, do you accept though that the court still had to satisfy itself beyond reasonable doubt that the accused did not entertain the mindset that he raised? Was that properly done in this case?
My submission is so that it was properly, that the presiding officer properly applied his mind to that, because there was enough evidence placed on record in cross-examination of the witnesses what the state of mind of the applicant was. There was no uncertainty about that at all.
Ms. Rose, isn't it so that it would be very risky to try and establish the applicant's state of mind exclusively from the evidence of the state witnesses, when indeed the applicant was in the box and there was an opportunity then for the state to put to the applicant what the state's position was with regard to the applicant's state of mind? In that regard, the court asked a question that prompted the state not to persist with that line of questioning. But it can't, in my view, be suggested that the court had made a decision. The state, which was dominus litis, had then made a decision not to persist with that line of cross-examination, and it must carry the consequences of that decision that it took. I don't understand the record to suggest that the court prevented. And does the problem not lie therein, in that an important opportunity to explore the state of mind of the appellant was not pursued, and thereafter the court was rather left in the zone of speculation that evidence wasn't before the court, and therefore that may not have been an irregularity, but rather that it points to an inadequacy in the ability of the state to prove guilt beyond reasonable doubt. What do you say about that?
Justice, yes, there is a lesson to be learned from that. I admit that, but my submission is that I could have asked so many questions about the state of mind, but the answer would be one of denial, that the applicant was aware that there were police officers, that he was informed.
No, but Ms. Roos, that happens in our court every day, that there's a sort of denial, but that's the motions through which the state must go in order to advance its case properly. And if you say there are lessons to be learned, there's some wisdom in that, but those lessons can't be learned at the prejudice of the appellant, can they?
Indeed so, Justice, but also I must admit that the state of mind of the applicant could also be inferred from the questions and put to Constable Liqhayiya during cross-examination of him.
Let me take you to sentence, which is what you were dealing with when we started asking or putting questions to you, Ms. Rose. A point was made, I may be mistaken, but I think it was by my brother, Justice Matopo. Some other colleague, I'm not sure, colleagues will correct me or forgive me if I'm wrong. But a point was made that if you believe, you subjectively believe, and it cannot really be said that the belief was unreasonable, that it is a criminal that is attacking you, and that it is not a law enforcement officer. Should that not in itself be a mitigating factor? Find the reality is you have killed a law enforcement officer, but when it comes to are there substantial and compelling factors, is that not one of them? Or in fact, the point made by my brother Justice Matopo, I think comes in even earlier. It says, does the section apply at all to that scenario? So one can look at it at two levels. Does the section apply at all? Or if it does the fact that subjectively and on reasonable grounds you believe you did not know that this was a law enforcement officer, isn't that a weighty factor towards saying, yes, there are compelling and substantial grounds for not imposing a minimum sentence? Please respond at both levels.
Indeed, so Justice, if it is clear from the records that the applicant believed that the people that arrested him was not law enforcement officers, yes, that is a very important factor when substantial and compelling circumstances come into play. But in this matter, the applicant was well aware that this was police officers when he stabbed both of them. And that is the reason why Section 51, subsection 1 is applicable, is because of that factor.
And what do you say about the double dipping argument raised by the applicant?
Sorry, Justice.
What do you say about the argument that says the court has relied on the fact of the killing of a law enforcement officer for purposes of saying the minimum sentence regime applies? But then the court again, when it is considering whether or not there are substantial and compelling reasons to depart from the minimum sentence, it then uses as aggravation, the sort of aggravation that brings to naught any mitigating factors. If I understand the argument correctly, it is that it is improper to use it twice in that manner.
Justice, my submission is that the presiding officer only took into account once that Section 51(1) is applicable because of the law enforcement officer that was killed. That is how I understand his approach towards the substantial and compelling circumstances, that it was not taken twice into account.
Do you have any further submissions, Ms. Rose?
No, thank you, Justice.
Can I just ask something, please, Justice Madlanga? The problem with the record bothers me tremendously, Ms. Rose. Which version of the judgment have you got? Because I had a look, the judgment published on SAFLI in this case is, from what I could see, the same as the one that we have, the one with the paragraphs and the subheadings. Which one have you got?
I heard Ms. Rose referring to paragraph numbers, and I suspected
yes. You know, I just want to confirm that.
Yes. No, my brother. No, not at all.
Justice, I have the transcribed one that already includes the paragraph numbers. That was transcribed line numbers.
Not paragraph numbers.
No, I have the one of the line numbers that was transcribed by the transcribers. That's
Yes,
one
that's the same one as Mr. Mkatobi is using. Yes, thank you.
Thank you for the clarification, my brother, because Ms. Ruas in her argument referred to paragraph numbers instead of lines. I was under the impression that she was not using the one that Mr. Liqhayiya used. Thank you for your question.
Sorry, Justice, I apologize for that error on my side.
That's in order. That's fine, Ms. Ruas. Thank you very much, Ms. Ruas. Mr. Liqhayiya.
Thank you, Justice Madlang. I only have 2 points to make. The first is to respond to Justice Mlambo.
Maybe just before that, Mr. Liqhayiya, Ms. Ruas, I'm sorry, Mr. Liqhayiya, Ms. Ruas. Yes, thank you. Assuming that we are not with Mr. Liqhayiya and we come to the conclusion that we cannot upset the conviction for lack of jurisdiction, but it is patently clear to us that the conviction was reached wrongly. Is there anything that can be done about that? I tried to look up the law, but I cannot say that I did so as extensively as one should have. What I was able to come up with, for example, is that in situations where new evidence comes up after the appellate process has been finalized, including all the way to the apex court, or without going to the apex court, but the doors for a further appeal are closed. Maybe, the time has run out, no likelihood of condonation and all of those things. So no appellate route at all. The evidence may, in terms of the Criminal Procedure Act, be placed before a judge. The judge may express a view on that evidence, and the matter may then be taken to the president. And the president may then sort of, I don't know, I've forgotten the language used in the Criminal Procedure Act, but effectively kill the conviction. I am not aware of a situation where there is no new evidence as to what may possibly be done if it is patently clear that a conviction was wrong, but we cannot do anything with the conviction because our jurisdiction is not engaged. Are you aware of any possible route?
No, according to also our submission, there's no other routes that can be utilized, except as the court referred to the precedent can be approached. That is all we have.
In a situation where there's new evidence.
Yeah, and new evidence, yes, the court can be approached.
Yes. All right.
And
all
then,
right. Yes, Ms. Rose.
Sorry, Justice, my colleague just referred to me to section 333 of Act 51 of 1997, where it states clearly that the minister, I believe the Minister of Justice, can also then be approached.
But that's where there's new evidence, not so.
Can we just have a moment, Justice?
All right, all right. Sorry for doing this to you, colleagues.
Justice, we just have a look at section 333, and our understanding is that if there's doubt, any doubt to the correctness of any decision given by any superior court in any criminal case on a question of law, or whenever a decision in any criminal case on a question of law is given, then the minister can be approached. So my understanding from that is that it doesn't matter whether there's new evidence.
Okay.
The minister can be approached.
Okay, that shows that my research was not thorough enough. Thank you very much, Ms. Ruas. Thank you. Yes, Mr. Mugaitobi.
Thank you, Justice Madlang. I wanted to first complete an answer I was trying to give to Justice Mlambo, but I didn't. The actual passage I was looking for is at typed page 66 of the cross-examination of Mr. Makhafila. At line, I would say 5, where Mr. Makhafila says, "No, my lord, he will be lying by so saying because he already knew by the time that we were police officers." That's where it's specifically put, the accused will deny that he knew at any stage that you were police officers. And then the second thing, just to bring to the court's attention, the view taken by the state on sentencing, at least, is in their supplementary heads at paragraph 5, where they say it is the respondent's respectful submission that in Homareda, the court was of the opinion that the sentencing court's discretion lies in the decision whether there are substantial or compelling circumstances, whilst the court in GK was of the opinion that it is not in itself a sentencing discretion. To this extent, there is uncertainty created in the approach to be followed, which provides this honorable court the opportunity to intervene and create legal certainty. So it seems quite clear that even on the state's submission, at least on sentencing, the jurisdiction is totally considered. And in fact, the state is of the view that the court must clarify what the law is on that issue. Insofar as
that would only be so, sorry, Mr. Natobi, that would only be so if we are convinced that indeed a proper reading of those judgments creates uncertainty and possible contradiction.
Oh, yes,
if they are as clear as you say they are, then there would be no basis for our jurisdiction to be engaged, at least on that aspect. Because I understood your argument to say those judgments are quite clear and compelling in terms of the fact that the court exercises a value judgment when it's dealing with the determination of substantial and compelling circumstances in terms of the minimum sentence legislation. Yeah.
Yes, and no, Justice Colapan, yes, that's true. What you've said about my submission is true, but the no refers to your premise, which is that I argue that the sentencing question is a constitutional question because it is an application of legislation on facts. And if the legislation was wrongly applied, then it's incumbent upon the court to correct it. The test or the standard you use in the correction is wide open. You are not bound by discretion. So that's what I'm suggesting. On the first question of, sorry, I see your lips are still moving, Justice Colapan. Let me shut up.
It's fine, but I just want to engage you on that because every time a court makes an error in terms of applying the legislation that it properly understands, but makes an error in terms of the determination of appropriate sentence would mean that this court's jurisdiction is engaged, and that surely can't be right.
No, you will still apply the other elements to granting of leave. You would still ask yourself, is a constitutional question raised? Is it in the public interest to hear the matter? Is it in the interest of justice to hear the matter? In which event you will then ask yourself questions about public interest and prospects of success. So it answers the first part of the test for leave to appeal, whether a constitutional matter is raised, but it doesn't answer the second part. The second part is answered by the need to clarify the test but it's also answered by whether we are correct in the sense of interest of justice. We are correct in our submission that there is disproportionality in the sentence. So in that way, you would then, your jurisdiction would then be engaged. That, of course, doesn't answer the more difficult part of my case, which is on what grounds are you going to ground your jurisdiction for the conviction part of the case? Now, there I offer the court the trial irregularities, which is about the conduct of a judicial officer in the course of a trial, where it has the consequences that there has been an unfair trial. And that would be a grounding for your jurisdiction on the conviction. Once you have grounded your jurisdiction on the trial irregularities, then it is open for you to revisit the correctness of the conviction, because the matter is properly before the court as a GPI matter, and you are simply considering whether or not this is a safe conviction. Could I end this by reminding the
Sorry,
court—
may I just interrupt you there? You may have gathered that, or let me say it, you may have gathered as much, but my prima facie view here accords with that of my brother Matlanga, that there appears to be very precarious grounds for conviction in this case. But how do we get there? And there's where my problem with jurisdiction comes in. Now, I get what you say about fair trial rights, but trial irregularity. But what if we don't get past that? My worry is then this other question, the second ground that I engaged you on earlier, and my problem there is with the record. And my question is simply one of a practical one. As I said to Ms. Roos, the Safley judgment is clearly the same one as the one we've got, the one with paragraphs and the one with subheadings and so on, which is different from the one you've got. It's one that appears to have been transcribed by the transcribers at the trial, no paragraphs and no headings. So which one do we work from? Because potentially the one may set out the correct test in the mouth of the judge, whereas the other one potentially may indicate that he has got the wrong test. And that is crucial to the question of jurisdiction, because if he sets out the right test and he misapplies it to the facts, then we know we're in Jiba and Busak territory. On the other hand, if he misconceived the legal test, then you may well have jurisdiction on that ground. So I'm trying to cover all bases, Mr. Mukatobi.
Yes, no, I appreciate the point. I think perhaps instead of trying to work out which of the two judgments, we should work on the facts that we know that there are two judgments, and that the one judgment mischaracterizes the test. And that would probably be a safer approach, which is you have jurisdiction precisely because there are two judgments, when in circumstances there should in fact be one judgment. So because
I want to ask whether, and I do this obviously on my own. I've not had a discussion with my colleagues, but I've just been thinking if we ask you and Ms. Rose to agree on the version that you have, that's the version both of you worked on, could we have a copy of that version? And then the other point that I would like to make is we can't just accept one or the other version. We must know why we do so, especially where a man's liberty is at stake, as in a case like this. The official judgment would be the one that was signed by the judge. Do we know which one it is?
Justice Machit, I wonder
That's how I understand it.
Yes, well, at least the good thing with this is that both me and my colleague are working from the same judgment. So the signed judgment is yes, it is in fact signed, is the one at page 162. Now I know that my attorney seems to have given me the wrong transcript. So the signed judgment is the one I was referring to. It's actually signed by Judge Ledwaba, DJP.
On behalf of Judge Bam.
On behalf of Judge Bam, yes.
So the Safley version is not the official version, put it that way.
Yes, it seems quite so that both actually on sentence and conviction, the signed versions are the ones that were read out in court, the ones that both me and Ms. Ross have been relying upon.
Mr. Nukatobi, I also have a signed copy of the judgment that the judges have been working, excuse me, the judgments that the judges have been working from. It's signed 19 September 2019, and that has paragraphs. It is an annexure. I'm not sure what it was an annexure to, but I have a signed copy of that judgment as well.
Yes.
Yes. Mine is also signed. Mine is also signed, yes, 19 September 2019.
I don't dispute
That doesn't
any-
solve the problem.
No, it still doesn't solve the problem. And that's why I come back to my original proposal to the court that you've got to work on the basis that you have two judgments. And that on its own is not conducive for fair trial rights of the accused, who is supposed to stay in prison for the rest of his life. And that one of those judgments gets the test patently wrong. And the second of those judgments, although it purports to articulate the test correctly, it misapplies it.
Mr. Nkayitobi?
Yes.
Can I just return to this question of the curtailment of the cross-examination and the irregularity that you say it gives rise to, assuming we were to accept that position as interfering with the fairness of the trial, what is the right remedy? You've said, well, that opens the door for this court to make an assessment of the correctness of the conviction.
Yes.
Wouldn't the usual remedy be to remit the matter back to the trial court for the unfairness to be cured and the trial then to take its course from that point on?
We would submit
before you respond, Mr. Nkayitobi, the 10 minutes is up. How much more time do you want?
Only 1 minute to respond to Justice Unterhalter.
Thank you.
Thank you. We would submit, Justice Unterhalter, that the correct remedy will be a finding overturning the conviction. Then it is up to the state to elect what it wants to do. We would say that it would not be in the interest of justice to effectively rerun the trial on behalf of the state. What the correct remedy is, once you are satisfied that there is a material irregularity that goes to the root of the fair trial, that you must set aside the conviction. And if the state wants to arraign and recharge or bring my client back, it's always entitled to do that. And it does not need this court's sanction for that route.
Because then we're in the domain of old cases like State versus Moodley and others, where the trial is vitiated by an irregularity set aside, and state as dominus litis must decide whether it's going to charge again. Yes.
Indeed. Justice Madlanga, thank you for the time. I have nothing else to say to the court.
Thank you very much, Mr. Nkayitobi. Judgment is reserved. Court adjourned.
Today's proceedings have concluded. The host will now terminate the